Good evening. Welcome on into the evening edition of From Day One. We pick up with the person who just won't realize it's time to leave the courtroom.
Was a judgment, and then the writ of eviction.
Well, I failed the October. I don't know how. I got confused. I'm not accustomed to the courts.
Ma'am, but if at any given time, here's what the problem for you, Miss Ma'am, and I'm just going to be blunt about it. That judgment went out from the court shortly after my signing. All right.
Sir, may I ask something of you? Once an agreement is made in court, isn't that you respectfully gave me the month to month. He told me if I drop the charges on his group, his client would agree to give me a month to month. I mean,
then you're going to have to file a new claim that alleges that. That's not before me.
That's why I motioned in August.
No, but that is not before me today.
This is how I will state it.
No,
wait.
won't.
Well,
That's not before me.
I can pay the money. There was never a failure. I swear, I had the money aside.
They want you out.
I didn't.
It's not about the money.
They asked me to.
It ain't about the money, but it might be about, websites crashing. So we will continue in audio form while I try to get the game back up as it crashed.
Pay. There was no probable cause in any level. I called his office respectfully. I asked him for the sheet of paper for the month to month that was agreed upon after August. She put a renewal underneath my door. If she wanted me to leave, why was she sending me a renewal? She tried to take the money out in September and October. That would mean I'm still on a month to month. I just said, where is the paperwork to confirm that? My bank has it on the record, JP Morgan Chase, September and October.
Ma'am, they want you out.
But she asked me to renew.
Ma'am, I don't know about any of those conversations. They have properly been granted a judgment for possession. They properly filed the writ or the order of eviction. I've signed the order of eviction. There is no basis, and I've listened to everything you said to me. There is no basis for this court to set aside that judgment or to stay the execution of the order of eviction or the writ of restitution. There's no legal basis.
I can't pay the money that was agreed upon.
They don't want the money.
Even though she tried to take it out in September and October.
This is a termination of tenancy case. I don't know anything that they've done regarding taking it out. This is
They did. They tried to take the money out.
Okay, ma'am, that's fine. I don't know that. But even if that were true, the judgment in this case.
I have not done anything though, Your Honor. I mean, this is against the law.
No, what would be against the law is for me to grant your relief you're requesting. Because they, like you have rights, they have rights. You brought this before the court. And I'm going to say it again to you, so hopefully it'll sink in. They properly got a judgment. Upon properly getting that judgment, they properly requested an order of eviction. I issued the order of eviction. That order of eviction, the judgment, because you have not provided a basis that will stand. Your motion.
I did nothing after August other than oblige where a month to month was concerned. That was the agreement. I did not refuse payment. There was no probable cause. She put a renewal underneath my door. I says, well, where's the sheet of paper if you're trying to renew? And then she's flip-flopping back and forth with me. Well, I'm like, okay, I thought I was supposed to be on a month to month. That's all it was. She lied to me. And then she lied to me again. And then she tried to take the money out 3 times. So it got me confused. I'm like, well, then am I on a month to month? The bank has that on record. So I came in thinking that if I spoke the truth, because I was sworn in last year and it was agreed upon that I'd be on a month to month after August. That was it. It was as simple as that. I contacted your courts on numerous occasions prior to the end of August.
Ma'am, maybe you don't understand. I just issued my ruling. Your motion is denied. What I will indicate is that the escrow will be held for 15 days and then it will be released back to the defendant. I will not pay the escrow over to the plaintiff. It will be released back to the defendant in this case. Thank you.
So what is the
Thank you,
time
Judge.
frame to, may I have till the end of January, sir?
Ma'am, you're operating on borrowed time. I signed the writ
I cannot just,
December 3rd. I signed the writ December 3rd.
to have a moving truck in, please, sir. I mean, it is the dead of winter. I have no problem moving out. I've been looking for another place because I don't trust these people. First, they're making an agreement with me and then they're flip-flopping. Could you please, a little courtesy where this is concerned, please?
You've not granted me any courtesy in terms of your talking. Why should I grant you any? But despite that, the writ will not execute prior to January 16th. So I will give you
So-
that, I will give you that grace of 10 days, and if I hear anything else, I may take that.
So I have to be out of this place by January 16th?
They cannot execute the writ prior to that date,
Okay,
because otherwise they could do it tomorrow.
right.
I am giving that 10-day, I'm giving you that period. I'm not giving you to the end of the month. I'm giving you that period. That's as far as I'm going. I'm done.
I don't know what I did and I feel swindled.
Judge, should I enter a order to that effect or will the court? produce
Yes,
the
sir.
order?
Please,
Okay,
please.
thank you. I will
Prepare
email.
an order under the 7-day rule, please.
I'll do that.
Thank
Thank you,
you.
Judge. Have a great day.
You do the same, but too late.
The escrow itself, when does that get repaid to me?
You need to listen to what I just told you. 15 days, I will release the escrow back.
May I enter a bank account number or an
No.
address to you?
No,
I have to give you a different address because if I'm not going to be living here,
ma'am, you can give it to the clerk's office any day. I'm done. You need to leave my. A. Wait a minute.
Even though the judge is quiet, she still hasn't left.
14A stands adjourned.
And finally, she leaves. Just 1 second. Let me see if we have any quick court cases to fill in the rest of the time.
We begin with another new development in the sale of one of the largest homes in Tennessee. Erica Elliott is charged with filing a fraudulent lien on the Villa Colina in Knoxville. That lien held up the sale of that 40,000 square foot mansion for months.
Elliott's trial was supposed to begin today, but in yet another bizarre twist to this case, she didn't show up. 10 News reporter Vinay Simlot was in the courtroom and joins us now. Vinay.
Robin, as we've reported, the liens and Elliott's court filings have the markings of a sovereign citizen. I was in the court for this trial at 9 a.m., but by 10, she still wasn't there.
Yeah, I think their goal is to intimidate, harass, retaliate, and delay.
In another delay at 9 o'clock this morning, Erica Elliott didn't show up for her trial. The judge gave her until 9:30 to appear, then 10 o'clock. At that point, Judge Kyle Hickson issued a capias, a command that Miss Elliott be arrested and brought to court. Law enforcement arrested her near the federal building across the street, but the witnesses and jury had already left.
The document that Miss Elliott presented for recording has the characteristics of a sovereign citizen.
Nick McBride is the Knox County Register of Deeds and a witness for the trial. The Southern Poverty Law Center says sovereign citizens place bogus liens on properties. They try to stop official business and clog up the courts. District Attorney General Dave Clark has prosecuted sovereign citizens in Anderson County.
Tennessee judges and prosecutors and police officers are not going to be intimidated by paper terrorism.
The Register of Deeds says Elliott's lien delayed the sale of the Villa Colina, even though she had no right to the property.
In order to buy a piece of property, you want to have free title.
Her charges in the trial today stem from filing that lien. Back at the Villa Colina, the sale officially went through on Thursday. The new owners plan to tear the house down and sell everything inside. Now the judge revoked Elliott's bail. She's now sitting in the Knox County Jail, charged with Class A felonies. That's the same class as a murder charge for filing that lien. There's another hearing in this tomorrow, Robin.
All right, Vinay, thank you.
And finally, we have an oldie but a goodie we've heard here before. We probably won't get through the entire of it, but we'll just listen just to fill out the time until we're done.
Police interact officers and more of the video, well as a call.
Here actually.
Well, we're all on level playing field, so which
I'd like to speak with the superior directly.
Okay. All right, well, you're speaking to me right now, so what do you need help with?
I would like to speak with the superior directly, sir. I want to make sure my constitutional rights are respected through this whole process and ordeal.
Okay, well, I'm here to protect your constitutional rights. That's what we're here for.
Okay.
Absolutely.
So who is the supervisor, though, just so I can direct my attention to the proper channel of authority for myself?
No supervisor here.
No supervisor. Okay. So, primary residence and my primary dwelling, my sole domicile. It was taken from me days ago. I immediately picked up the phone and called and filed a report for grand theft of South Boston Police Department, which Officer Perkins responded. He refused to provide any incident report or any investigation. Any information regarding my RV and a call to be removed.
No crime has been committed.
Yes, sir, it has. And
look, if you can let me finish talking first, and then you can talk, all right?
Yes,
that's
sir.
how this is going to work.
Prison of a felony.
Okay, look, you're going to stop talking and listen to me, okay? No crime has been taken. You parked your vehicle on a lot owned by somebody else. You can't park it there. That means he has a legal... Code of Virginia says you cannot leave any property that belongs to you on somebody else's name.
Can you furnish me that code?
I don't have to. I'm telling you.
Listen here, sir. With all due respect, this is why I requested a supervisor.
Deputy Moore informs Mr. Raposo that Virginia law prohibits an individual from parking on someone else's property. Section 46.2-1215 of the Virginia Code states that, quote, no person shall leave any motor vehicle, trailer, semi-trailer, or part of a motor vehicle, trailer, or semi-trailer on the private property of any other person without his consent. Additionally,
Yep, and
Section
that place actually happens to be the Walmart parking
46.2-1200
lot.
includes in the definition of an abandoned motor vehicle, quote, a motor vehicle, trailer, or semi-trailer that weighs at least 75 pounds and has remained for more than 48 hours on private property without the consent of the property's owner. And Section 46.2-1201 states that, quote, any county, city, or town may take any abandoned motor vehicle into custody. The locality may employ its own personnel, equipment, and facilities, or hire persons, equipment, and facilities, or firms or corporations that may be independent contractors for removing, preserving, storing, and selling at public auction abandoned motor vehicles. Given the available information, it seems likely that Mr. Raposo's RV was removed from the property under the authority granted by these statutes. However, Section 46.2-1215 goes on to state that any vehicle towed by law enforcement must have been left for more than 72 hours, and Mr. Raposo claims in many of his other videos that his RV was parked on the property for less than 24 hours. Nonetheless, the circumstances surrounding the actual towing would have to be debated within a courtroom, and it's very likely that a court would find that the officers were acting in good faith when the RV was towed.
This is misprision of a felony, refusing to take a report in regards to the felony, and you are acting as an attorney practicing law unlicensed right now, which is also a crime, and you are here to solely take a criminal report. In regards to
criminal report, nothing criminal has taken place.
Hold on 1 second, sir. I'm not trying to argue with you. I'm trying to educate you. Now, the Supreme Court had ruled that it is your sole duty to take a criminal report in regards, and if I am falsifying any information in regards to this report, you will be liable to arrest me. Now, with the state law and federal law considering, I'm going to educate you. Not at one point, at any point in time, was I made aware that I was trespassing. Therefore, it is a crime in regards to the removal of that vehicle from that property because nobody had made anybody aware that a crime's been committed. I'm going to elaborate for you in a clear instance. 1 second, sir.
No, he's talking, you stop talking, okay? That's how that works.
Wanted to
Again,
speak with
don't
the
elaborate.
so I didn't get gangbanged by a bunch of people who didn't study law.
Gangbang?
Do you know the person that owned the property you're parked on?
It's not owned by a private individual. It's owned by a private corporation.
Did that corporation give you permission to park there?
This property has been generally open and accessible to the public in the neighborhood for generations, as I can testify myself to that.
Was it closed when you parked
there? Are no posting signs whatsoever that would deem any portion of that property not open and accessible to the general public.
Mr. Raposo argues that he was not trespassing on private property because there were no signs posted and no one notified him that he could not park there. Section 18.2-119 of the Virginia Code defines the offense of criminal trespass as going upon the lands of another, quote, after having been forbidden to do so, either orally or in writing, or after having been forbidden to do so by a sign or signs posted on such lands at a place or places where it or they may be reasonably seen. However, while Mr. Raposo could not be prosecuted for criminal trespass because he had not been forbidden to enter the land and there were no signs posted, he could possibly be held liable in a civil lawsuit for trespass to land. The civil cause of action for trespass to land is recognized in Virginia under the common law, which is part of a state's body of laws that comes from customs and court decisions instead of statutes. In the 1994 case of Cooper versus Horn, the Supreme Court of Virginia outlined the requirements for a cause of action for common law trespass to land.
And I'm going to stop that guy right there. Basically, it boils down to that he called and basically told the tow yard that he was a cop, so they end up towing him and arresting him in the end. If you want to hear the whole one, go ahead and watch one of my previous episodes if I remember. I'll try to get a link to whichever From Day One episode had that in its entirety. Until then, we'll bring this day to a close here on From Day One. As always, please like, share, and subscribe. Be kind to one another and release the Krakens as we march along this evening and every evening from Day One. Have a great night, everybody.